Welcome, and thank you for joining us today for a Land Services SA webinar on the Compliance Program and the Retention of Evidence. This is a pre-recorded session with a live Q&A opportunity at the end of this presentation. We ask you to kindly hold all your questions until the allocated time, where one of our subject matter experts will be happy to assist. Land Services SA is committed to providing an excellent customer experience. One way we continue to deliver value to the industry is through our industry education program, where we produce a range of helpful educational materials, hold regular webinars, and host industry events. Our industry education program addresses key topics or frequently asked questions to ensure you remain up to date with contemporary practices. We want to help set you up for success and believe helping with industry education will help reduce the volume of requisitions, meaning a quicker and more seamless experience for your clients. Land Services SA's subject matter experts assist in delivering our industry education program, utilising their years of experience and respected place in the industry. This webinar was prepared by Alistair Byrne, the Senior Registration Officer at Land Services SA. Alistair has over 28 years of experience with the Lands Titles Office and has a wealth of knowledge on the technical and legislative requirements. In this session, we will be covering the compliance audit process, client authorisation, verification of identity, verification of authority, reasonable steps, acceptable practices, and avoidable mistakes. Under the Electronic Conveyancing National Law, subscribers are required to comply with participation rules made by the Registrar in each state and territory. The model participation rules have been developed by ARNIC for determination by each registrar before coming into effect in that jurisdiction as participation rules in accordance with Section 23 of the Electronic Conveyancing National Law. South Australia's participation rules for Electronic Conveyancing version 7 became effective on the 28th of March 2024. These rules are available to view on our website landservices.com.au under the Land Registration for Professionals menu options. Compliance examinations were introduced in October 2016, following the commencement of the Real Property Electronic Conveyancing Amendment Act 2016. Requirements have been aligned for both electronic and paper transactions. Under Section 220A of the Real Property Act 1886 and Section 33 of the Electronic Conveyancing National Law South Australia Act 2013, the Registrar-General has the power to undertake a compliance examination as part of the administration and the enforcement of these acts. The nationally aligned compliance program has been established to monitor that the obligations and practices that support the certifications made by legal practitioner, registered conveyancer, or mortgagee are being met as they relate to client authorisation, verification of identity, verification of authority, also known as right to deal, and retention of evidence. Land Services SA audits over 600 dealings each year, covering a range of transactions inclusive of transfers, mortgages, encumbrances, leases, and many others. A strong focus of the program has been on assisting and educating industry on current conveyancing requirements. Further information on each of these areas can be found within the Model Participation Rules Guidance Notes, which are available on the ARNIC website, arnic.gov.au. Representatives are selected at random, and audits will be initiated by a written notice from Land Services SA on behalf of the Registrar General to the representative. Representatives may also be subject to an audit in certain instances where they are newly registered, have not been examined before, past examinations have been unsatisfactory, or the Registrar General has identified an issue with a particular transaction. The compliance notice will be sent to the email address recorded in the representative's agent code details, so please ensure your contact details on these agent codes are kept up to date for both lodgement mediums, paper via Land Services SA and electronic via the Electronic Lodgement Network Operator. The notice will outline which transactions require evidence of compliance to be produced. The representative has 10 business days from the date which the notice was sent to produce the required evidence. Copies of evidence and supporting information can be provided to Land Services SA by email to lcocompliance@landservices.com.au, in person at Level 9, 101 Grenfell Street, or by registered mail. In each case, representatives will receive an acknowledgement of receipt via email. Land Services SA will conduct a desktop evaluation of the documentation submitted against the transactions selected for examination. Once complete, the representative will receive notification by email of the examination results. An outcome notice of satisfactory compliance will require no further action or correspondence. An outcome notice for an unsatisfactory compliance result may require the representative to provide further documentary evidence or provide a written explanation addressing the deficiencies identified and outlining the controls to be put in place to prevent a reoccurrence, or, in circumstances of gross deficiency, a face-to-face interview with the representative or an on-site visit to their office may be requested. Please be aware that failing to comply with the examination notice without reasonable excuse is a suspension event that may result in the commencement of the suspension and termination procedure as set out in Schedule 7 of ARNIC's Model Participation Rules. Inquiries regarding the compliance program should be directed to the email address as shown on this slide. Further information can be found in the ARNIC Model Participation Rules Guidance Note 6. A client authorisation is required where a party to a real property transaction requests a registered conveyancer or legal practitioner to act on their behalf. A client authorisation form is required under the Model Participation Rules and Part 20A of the Real Property Act for this purpose. The current version of this form, version 7, became effective on the 28th of March 2024 and must be used for all client authorisations signed from this date. The latest version of the form is available on the ARNIC website in either a smart form, Word document, or PDF format. The Registrar General's verification of identity requirements provides the framework for legal practitioners, conveyancers, or mortgagees to take reasonable steps to verify the identity of a party to a conveyancing transaction. The purpose of carrying out verification of identity, VOI, is to reduce the risk of identity fraud and the registration of fraudulent land transactions. The VOI of clients and mortgagors is considered to be part of the due diligence required of conveyancing professionals. A standard for undertaking VOI in electronic conveyancing transactions is set out in the South Australian Participation Rules. This will apply to all conveyancing transactions that are conducted by a subscriber to an electronic lodgement network operator, an ELNO, and lodged with the Land Registry electronically. For those paper conveyancing transactions that fall outside the scope of electronic lodgement through an ELNO, the requirements for VOI are specified in the current Registrar General's Verification of Identity requirements, which can be located on Land Services SA's website. The Registrar General's Verification of Authority guidelines help legal practitioners, conveyancers, or mortgagees to take reasonable steps to verify the authority of a party to a conveyancing transaction. These requirements apply to paper instruments and documents under the Real Property Act and are consistent with the verification of authority or right to deal rules introduced for national electronic conveyancing. The Electronic Conveyancing National Law South Australia Act 2013 requires parties to electronic conveyancing transactions to have their authority to enter into the transaction verified. See the Right to Deal Model Participation Rules Guidance Note 5 at www.arnic.gov.au. Evidence supporting verification of authority or right to deal may include council rate notice, an emergency services levy or land tax bill, the grant of probate or death certificate, or a sales contract for purchases. Please note that government searches, such as a register search, can also be used as supporting evidence, but on its own does not constitute sufficient evidence to meet verification of authority requirements. Reasonable steps is a commonly used legal concept. When applied to subscribers and mortgagees, it means the taking of such steps as an ordinarily prudent subscriber or mortgagee would have taken in the circumstances and in the ordinary course of their business. Whether reasonable steps were taken will be a question of fact, depending on the circumstances of the individual case. Ultimately, this will be determined by a court on an objective basis. Evidence may be stored electronically or in paper. It could be stored by the representative and/or an agent on a representative's behalf. However, the medium and means in which documents supporting the transaction are to be retained is to be determined by the representative in consideration of a potential dispute and the need to produce those documents as evidence in a court of law. Evidence must be accessible, legible, and safely and securely stored, whichever medium is used, for a minimum of 7 years. Please note, for mortgages, a copy of the mortgage signed by the mortgagor and held on the same terms must be retained by the mortgagee until the mortgagee ceases to be the mortgagee. Further information can be found in the ARNIC Model Participation Rules, Guidance Note 5. Some easily avoidable mistakes we encounter whilst conducting examinations include not retaining copies of evidence on file, not meeting verification of authority requirements or relying on insufficient evidence, not documenting reasonable steps taken, for instance, when the verification of identity standard is not applied, not ensuring sufficient identity documents are obtained to tie up any changes of name, such as marriage and divorce certificates, using out-of-date templates. We see many client authorisations which are not the current version, therefore not complying with participation rules. Not completing client authorisation in full. For example, you need to ensure the most appropriate authority type has been used, All sections of the form have been fully and properly completed. Client and agent or agent representative sections have been completed in full and signed correctly. Maintain simple practices such as retaining evidence for the required period, clearly document the steps taken. If using a verification agent, ensure their processes are up to date and meet requirements. Stay up to date and consider additional steps if in doubt. In summary, some key points to take away should include accurately complete all sections of a client authorisation, align the timing of VOI and the signing of client authorisation, document the steps taken, and consider additional steps if in doubt. Land Services SA's website has a range of educational and support materials to assist you in your day-to-day work. Our Industry Education Hub is a good place to start. This can be found by clicking Industry Education Hub on the homepage of Land Services SA's website. A copy of today's webinar will be published on the Industry Education Hub together with recordings of previously held webinars. That concludes the recorded webinar section. Thank you for listening. Please remain online for the live Q&A session with our subject matter experts.